here I welcome all the faculties who attend this section for this seminar. I also welcome Dr. Suresh sir, our senior professor in physics, to this section. Also, I welcome our IQC coordinator and Dr. IQC coordinator Najila and IPR cell convener Dr. Jisha for this section.
Thank you, Dinil sir. Now I request Dr. V.C. Suresh, Associate Professor, Department of Physics, to chair the session. Sir, please.
Good afternoon. Nice to be with you all, though remotely. Today, we are into the third day of this online workshop. Today's talk, as you all know, is on the significance of intellectual property rights in research. Well, it's imperative that those of us who have a doctoral degree, or maybe those who are into serious academic research, should definitely be aware of the facts regarding IPR. One should know the implications of the copyrights and related issues. In what way you can safeguard your works, your published papers, your reference works, maybe your technical drawings you have created as part of your work, etc. On the other hand, industrial property rights provide rules and regulations to protect patents, trademarks we have created, industrial designs and similar other contributions we have made as part of our research activities. Today we would hear all about this from Dr. Ajit Prabhu. He's an expert in IPR and he's somebody with lots of experience in the practice and implementation of this. I think I should say a few words to introduce our resource person to all of you. Dr. Ajit was originally with ISRO, Liquid Propulsion System Center, but presently he is holding very key positions as one as Chief Scientist in the Kerala State Council for Science, Technology and Environment, and he is also Nodal Officer in our state's Intellectual Property Rights Information Center. He has been showing very keen interest in coordinating programs for promoting awareness in IPR. Actually, he's very actively involved and he's managing quite a few number of IPR cells in various universities and colleges and other institutions. He has lots of experience in varied fields like energy management, entrepreneurship development, and preparation of state project proposals and budgets. And he's conducting patent research and he's facilitating institutions as well as individuals to file patents. And besides this, he's also a member of many prestigious professional bodies. Well, Dr. Ajit is here with us for the presentation. Let us once again accord him a very warm welcome. I'm sure you all would be profoundly benefited listening to him today. Wish you all a very productive session. Thank you all. Over to you, Dr. Ajit.
Thank you, Chairman. Nice introduction. Am I audible? Am I audible? Can I speak?
Yes, you are audible, sir.
Okay. Respected Chairman, respected Principal of MES College, other distinguished participants, I am extremely happy today to associate with this program targeted for researchers to promote research in our state. I start with the statement Dr. Dinil has made that Kerala state, though we boast that we are number one in many cases, it is a pitiable state that as far as patent and IPR are concerned, our state is not number one in the country. Probably very low status in that aspect. Even to mention with a sad note that Mother University in Kerala, which is Kerala University, having 80 years old, you will be surprised to know that it is left with just 2 patents. Last week, Dr. Achyut Shankar, in another context, was making a lecture, and he was telling that in foreign countries, in many universities, especially private universities, make 300 to generate 300 to 400 patents on an average in a year. It is not just like Mr. Dinil has told, it is not that we have no intellectual resources here. I strongly believe that in our God's own country, we have the immense resources and intellectual resources. Absolutely no doubt about that. We are very, very talented and brilliant guys. But what is happening here? Is it that no innovations are happening? No inventions are happening? No research is happening? Yes, it is happening. The same people or resource persons from Kerala are going to abroad and generating large amount of IPs. So the problem is, number one, lack of awareness. Number two, there are a lot of myths about patent. Getting a patent is very cumbersome, very expensive affair, and so many other things. Anyway, I don't want to give a wide introduction because now my subject is very specific and my time allotted is also very short. And I have to tell you a lot of things about how or the role of IPR for researchers. So I have made a small presentation so that I will not leave out any points. I will straight away go to the presentation, and in between also maybe I may deliberate on certain general aspects. Can all of you see these slides? Hello?
Yes, sir. But you can make it in the presentation mode.
I will do that. I will do.
Okay.
Is it okay now? Hello?
Not exactly.
See to side of there, sir.
Okay.
Is it okay?
It's
Isha,
not full
please.
screen.
It's not.
Nobody is
It's
seeing?
like two slides, sir.
No, sir.
One over the other.
Okay.
Full screen,
No,
sir.
sir, the
It's
slide-
like two slides or one over the other.
Just 1 second. Some technical problem.
Okay, sir.
Is it okay now? Hello.
It's same as previously.
Is this okay? Hello.
It's not okay, sir, right? It's not in the presentation mode still. Full screen sharing can be given. Full screen. Can you try to move the slide to the second slide? Maybe it may be coming.
Is this okay now? Isha?
Yeah, yes, it's okay, sir, now.
Now it's okay.
Yeah.
Okay.
You can continue.
Sorry
Thank
for
you.
the technical problem. My team successfully made it. Mr. Atul and Mr. Safiq, they helped me in getting this back. So my talk is on role of IPR for researchers. Why IPR is important for researchers and how it is important and how you can make use of IP in the research application. I am sure most of you or all of you are faculty in one branch or the other, in one stream, science or other, and perhaps you are aware of what is the outcome of a research. What could be the outcome of a research? It may be definitely a new knowledge, okay, or maybe it may be a new theory if it is a fundamental research or basic research. It can be a new theory or new philosophy. It may be a new process also, maybe biotechnology, chemical process, and so many other processes are there. Maybe a new product as such. Suppose you have no product existing and you do research and bring out a new product, and already we know a lot of products. We are in the best of its living standards now with a lot of products, and all these things leads to invention or innovation. There is only slight difference between invention and innovation. I am sure you know. Invention put to practical application or marketing application, it becomes innovation. Or innovation is any little improvement or any new thing that you do which has got marketability. That is called innovation. Invention is that you do in labs and other things, and you do extensive research and bring out something new. That is invention. And the output of research will be maybe normally a research report. It may be a thesis, it may be a research report, or maybe it may end up with a paper or article. Usually in academic forum, that is what I was referring to Kerala University also. If you look at publications, it is at the top. That is why Kerala University is still one among the top universities in India. Because of publications, lot of papers, lot of articles, and maybe presentation in conference. You can present that research output in a conference, or you can prepare your other a book or a chapter in a book, or maybe patents. You can get a patent also from the research output, and you can get some awards and other things. So coming to a research cycle, obviously all of you know what is a research cycle. But it starts with a research problem. You call it a research, sorry. Hello? Is it okay? Or?
Yeah, everything is fine, sir.
No,
Fine.
presentation. You can see the presentation now?
No, presentation is not.
One second.
Okay, sir.
Okay, now you climb the tree. Hello?
Yes, sir. It's okay.
Okay.
ശരിയാ സാറേ.
So, any research starts with a research problem. You ask research questions. Why? Why this is so? What that factor? How? And these questions you develop based on literature review. You do extensive literature review. Of course, my presentation will have mainly two parts. Number one, how you do literature review, and analogous to that or similar to that, how can you do patent review and arrive at a patent. Probably all of you are familiar with literature review and you know how to do a publication. For that, what you do step by step, Similar way, how can you do a patent review to get a patent? That would be main aspect that I will be speaking in this lecture. So you do literature review. Why you do literature review, I will be explaining in the subsequent slides. And you develop the research hypotheses, you form certain hypotheses, you do the testing of hypotheses. For that, you may generate some data, analyze the data, do interpretation, and conclude your research. And again, go to the research question and asking whether the research problem is solved or not. Again, you do. This is called the research cycle. Why you do literature review? It is a critical analysis of existing research in your field. That is what is called literature review. It highlights both the strengths and weaknesses of existing research. In any field of your research, any field, let it be mechanical engineering, electrical engineering, physics, chemistry, biology, research is happening all over the world. Probably we are not aware of that. So how can we know what is the level of research happening in that particular area? Because there should not be any duplication of research. So that is what is called literature review. So it allows you to gain a critical understanding of your field. What is the state of the art technology? Where do the research end now? Where or what is my scope to start my research? So it is an opportunity to think about what has been done in your field, opportunity to think about similarities, patterns, trends, and also differences across the existing research. And you identify the gap in the literature. Probably that should be your interest while you are looking for a literature review. Probably that makes different from literature review, different from literature survey. Literature survey means you simply survey, but in review, you critically review each literature survey you have carried out and try to identify what is the gap the other researcher has not answered, not addressed to, which I should address. So it is more than a chapter in a thesis. It is literature review as an outcome appears in the final draft of your thesis, as you know, but it is a process. It's a critical engagement. It is a critical thinking, reading and writing with relevant research on your topic. It is a crucial and formative stage of your research journey. So for undergraduate level, it may be backing your points with appropriate and authoritative sources. At master's PG level, demonstrating that you understand how knowledge is created. And at PhD level, it demonstrating that you can create new and original knowledge different from the existing one. I repeat, new and original knowledge different from existing one. So for professional academic, for peer review, building a coherent body of work of your own and assuring others' work, etc. So I am skipping this already, I have mentioned. So the researcher's perspective should be, suppose you create something, you have a creation, research output. You have to think whether it is new or not. If it is not new, don't proceed, you again go and create. You think how you can do something new, again create, do something new. So this is a cycle. And if it is new, then you have to think whether should I keep it as a secret or public. Of course, I had some more slides which I purposefully avoided because of time constraints. You know, in academic research, pure academic research is happening, but the trend is now industry instituted research. Industry would be interested to do certain research. Probably they don't have research capability. Academic researchers may not have infrastructural and other financial resources to do particular research. So that is why these two things are combined. And mostly, then the researcher can think whether it should be kept as a secret. If you are doing it for an industry, definitely that industry owns that knowledge. If you do it your own, there also you can decide whether you want to keep it secret or you want to leave it to the public. If you keep it secret, unless and until it rolls out from your mind or from your lab, it has no value. It has no value. I have a lot of examples, but because of time constraints, I don't go into that. So definitely you have to leave it to public. And then comes again questions. How you are going to publish it, whether it is by publishing a paper, article, or something in journal or conferences, or you are going to file a patent. If you are going to file a patent, then file a patent first and then you can publish also. So you get both the advantages of patenting as well as publishing. If you publish first, you can't patent. If you patent, you can patent as well as publish also. And once you patent, you become one of the scientists among the elite class of patent holders. That is a great recognition. Also, that associates with a lot of money. If the new knowledge is that much phenomenally useful for the society, that involves large amount of money, especially in this knowledge economy. This kind of new knowledge has got immense wealth. That is the source of wealth now. So my next part is what is IPR and what for IPR. IPR is the tool to protect inventions, creations, and new knowledge. Probably yesterday, my colleague, Mr. Safiq, the patent scientist, might have taken a session on IPR or patents rather. So intellectual property is that which results from creations of intellect. What comes out from the intellect? That is called intellectual property in industrial, scientific, literary, or artistic field. And intellectual property rights is the legal right or legally enforceable exclusive right granted to the owner of the intellectual property for a limited period. So this is the difference between intellectual property and intellectual property rights. Unlike our traditional property, like movable property or immovable property, intellectual property is invisible property. intangible, you call it. You can't see unless and until it takes the shape of a product or a process or an art or a painting or photograph or some sculpture or something. So as per TRIPS agreements, there are 7 forms of IPR, that is patent, copyrights, trademarks, industrial designs, layout designs of ICs, geographical indications, and trade secrets. So I will be just giving a glance of all these forms of IPR because that would be useful for the next session. Also, this IP is governed by various IPR laws in our country. You know, all IPs are generally territorial in nature, and it is governed by law of the country. And in India, you know, you can see patent, all kind of patent that is coming under Patent Act 1970. Then trademark comes under Trademark Act 1999, Design Act 2000, Geographical Indications of Goods Act 99, Copyright Act 1857, and these are basic law act, but it is of course repealed and all. Semiconductor Layout Act, that is 2000, etc. Sorry. So this is the intellectual property, various intellectual property IP offices in the country, and you can see this is plant variety protection. This is for semiconductor design, this thing that is in Delhi, this plant variety protection office that's also in Delhi. There is a training institute in Nagpur that is called Rajiv Gandhi National Institute for IP Management. And there are 4 patent offices in the country, Kolkata, then Delhi, Chennai, and Mumbai. Sorry. So then design, Calcutta, trademark. I am not going into that. So this is our mostly our. For us, that means in South India, our concerned office is IP office at Chennai. Patent is a right awarded by the government of India to an individual or a group of individuals, that means collectively, or a legal entity, maybe an institution, for exclusive use of their inventions and disallowing others to use, practice, sell, or market that invention without their consent or permission. That is why it is called exclusive right. If you have a patent on any product, technical product, so without your consent, nobody can make it or market it. So right is intangible in nature. It is not like a building or a motor vehicle which can be seen, felt, or anything. So the monopoly right, it is the monopoly right given by the government in exchange of your making the invention public through a patent document. So while filing a patent, you have to disclose all the details of the invention. So for disclosing
Excuse me, sir.
Yes.
Sir, sorry to interrupt you, sir. Sir, your presentation is not visible, sir.
Is it only to you or for all? Please.
No, I think 2-3 persons have present. Yeah, to all.
One second, please. Is it okay now? Now?
It's okay now.
It is okay. Okay. Thank you for alerting me. Otherwise, I would be going on speaking. Good. Okay.
Thank you.
So it is a monopoly right, and patent validity is for 20 years from the date of filing. So the subject matter of patent is, in fact, 3 already I have mentioned. Novelty is the fundamental subject matter or characteristics for applying for a patent. Normally, that is where people are confused. What I do is novel. Will there be novelty? So how to do the check for novelty? I will come to that my next presentation part. But novelty is, please understand that it is unanticipated, undisclosed, and not in the prior art. That means there should not be any patent on that invention. There should not be any matter published as paper or journal or published in conference or something. So it should not go to the public in any case. That is called novelty. The non-obviousness means it has an inventive step. I'm not going into the details because I hope to the same audience, my colleague has explained very well what is non-obviousness and inventive step and usefulness. Any invention must have industrial application. So this is called a Nunn's test: novelty, usefulness, non-obviousness, and there are certain statutory things, like which cannot be patented, and I will come to that later. So if the patent application or the novel idea, or novel product or something which suits these four things, you can definitely file a patent. So there are a lot of rights for a patentee. I'm extremely sorry that I have to run through because my main focus of presentation is still lying there. So I have to run through this part because it is 3 o'clock now. So there are a lot of rights: right to exploit the patent, right to assign and license, right to surrender, etc. So a patent allows you to sell the invention and all the intellectual property rights. Maybe you can license the invention, discuss the invention with others, industry and industrial collaboration, etc. Just one example I am giving. Many a times I speak with the same example because it carries a lot of things to understand. An inventor has developed this pulling up tab like Coke can, what you call it in an easiest way. You look at the end, during the period of validity of the patent, he is making a royalty somewhat around 1,48,000 UK pounds a day, nearly 2 crores a day. That is his income. You see, a small idea, how much wealth is involved into that. So that is why patent is considered as something at higher level, something great, because it involves, it contains a lot of wealth. There are product patents, process patent, product by process patents, and the term is 20 years. And probably I'm sure this also might have been covered. Non-patentable items like frivolous and against law of nature, contrary to public order or morality, mere discovery, only inventions can be patentable, not discovery, new form of a known substance, then admixture, making two things together and claiming that it is a new thing, you won't get a patent, method of agriculture, horticulture, mathematical game or playing a game, anything related to atomic energy, etc. are generally not patentable. Also, those who wish to do publication in conference and all, a shortcut is that you apply for a provisional specification. That is otherwise called provisional patent. What you can do is whatever findings that you have done in the research, maybe lab or the research output, all those things you can document and submit to the patent office, and that will along with a form 1, I think some fees is also there, 1,000 rupees or so. So in form 1 you fill up your details, your name, institution name, etc., and along with that you file this document. Then you file a provisional patent. Then it is for sure that you are the inventor and you are pursuing the research, and within 12 months of time you have to submit the complete specification. So you get a time period also. And so the advantages are priority for invention. Suppose tomorrow somebody else is filing a patent, you have every legal right to say that yes, I have submitted a provisional before that, so I am the inventor. He has actually stolen that thing from me, or he is misappropriating something like that. So no risk of losing property priority. You have again liberty to further develop it, and you can disclose to interested person to obtain financial support. Maybe you can discuss for industrial collaboration, etc., etc. So those are the advantages. And this is I told Indian Patent Act 1970, which is amended in 2005. So there should be good attitude. You publish or no patent, that means you may get recognition in the academic forum. You will get a lot of recognition. So and so has got a lot of publications, but no money. But you patent and no publication, then you can make a lot of money depending upon the worth of the invention, but no recognition. But patent and then publish, you make a lot of money, you make wealth, as well as you get recognition also. So that is why we always tell in the academic forum, either publish or perish, or patent and prosper. So this is the patent filing procedure. I will run through that quickly. You file a patent, and there will be an examination. After 18 months, it will be subjected for examination, or for a publication. You can go for early publication also, and pre-grant representation by any person, any opposition is there. Chance is there. Then request for examination you have to do. Then there also early examination request you can do. Then grant of refusal or something is there. Then again publication of the grant of patent in the Gazette. Then post-grant opposition and decision by the controller, and then patent is granted. So this is in nutshell the procedure followed in patent office. Then comes the second item, copyright. Copyright, it is for it is not a right to copy, but it is a reward for the author. It stimulates artistic creativity. Copyright is the exclusive right granted to the owner of a literary, artistic, or scientific work to use or authorize others to use it for its reproduction, public performance, translation, and adaptation. So the main criterion for the protection of a work under copyright law is that it should be original. There is no clause that should be new, but it should be original. Whereas in patent, it is new. That is another condition. So it is for literary, dramatic, and musical work, etc., artistic work, cinematographic, film, sound recording, broadcasting, performance rights, etc., etc. So copyright involves a bundle of rights. In fact, a right for reproduction, a right for adaptation and translation, right of distribution, right of public performance, right of broadcasting, etc. So I'm just going through. So yeah, so the term is actually for authoring a book or so, lifetime of the author plus 60 years of literary work, and 60 years from the date of registration for cinematographic as well as sound recording, etc., and broadcasters' right, performers' right for 20 years. This is the act. Then third one is trademark. As you know, any product is made distinctive with the mark. You can see Microsoft, and here you can see R within the circle. That is registered trademark. So you know what is Microsoft. It is different from other products. So in market, anything you designate, whether it is Nike, whether Pepsi, Cadbury, V-Guard, Coca-Cola, Adidas, all what you name is called trademark. Once it is in the market, you call it as a brand. So a trademark can be a word, mark such as Ford, Toyota, Annapurna, etc. It can be an abbreviation like IBM, etc. It can be made out of devices or figurative elements, logos, anything which should be distinct. That's all. For example, GE. Just then or letter combinations, alphanumeric slogans like Intel Inside, colors, different color combination, etc. These are the act. And then fourth one is industrial design. Industrial design is, of course, features or shape, physical shape. You can see here a bottle. How does it look? A kettle. How does it look? A chair. How does it look? So the physical appearance. How does it look like? That is called that is a design, and that is covered under industrial design. And it should be only appealing to eye. And as per TRIPS protection, the protection is initially for 10 years, and then 5 more years you will get. Then Yeah, these are different law. You can see it is very clear from different design forms. See different bikes you purchase, depending upon its shape and design only. Probably the engine remains the same. So you understand how much value is associated with that design on that product. Okay. Then comes geographical indication, GI. You might have heard of lot of materials like Darjeeling tea, Kanjipuram silk, French champagne, etc. So that is actually it's a origin. It's a sign used on products that have a specific geographical origin and possess qualities and reputation that are due to that original place of origin. So, signs to identify goods originating from a territory. It is only for goods. It may be agricultural products, industrial products also, no problem. Must originate from defined area. And see Aranmula Kannadi, Kondapalli toys, Channapatna toys, Mysore Rosewood Inway, Pochampalli Sari, etc. So the key attributes are uniqueness, quality, and reputation. These are different GIs from Kerala, Aranmula Kannadi, Payanur, Pavitra Ring, Nyavara, Palakkad Matta, Malabar pepper, Aleppi Kayar, Talasheri pepper, etc. Then comes layout designs of ICs. Those who are in electronics and computer science, you are more familiar with ICs and design of ICs. So that you can get protected. 10 years protection you will get. Then the last one, trade secret, like Coca-Cola, the trade secret is still not known to the world. So you can keep it along with your chest. That is called trade secret. So this is an overview about IPR. I know I was running through, but still you got a good idea about what are IPRs and all. Initially, I apprised you with what is meant by literature review. Now I am coming to that, a similar analogy. How can you do patent search and do patent review? And the intention is how your research can qualify to get a patent. Earlier, your research, you are planning to get a publication out of it. Now, apart from publication, how can you get a patent also from out of your research? That is why we do patent review. So, what is called prior art? Existing one. Any information in the public domain available in newspaper, magazines, journals, patents, all are called prior art database. So examples are, how can you get the prior art from particular invention, from patents, from books, from trade or professional journals, advertising catalogs, government documents, illustrations, etc. So how do you do, or why do you do patent search? To find out whether an invention is new and patentable. And prior to undertaking expense of filing, or because filing involves little money also, so you need not expend for that. And whether a patent application should be filed or not. So it gives information about inventors, owners of the patents, etc. So that companies can start tying up, etc. Identify competitors for the same technology. What is the level at which the technology is? For example, it may be touchscreen technology or some other technology. Then searching by patent attributes. How can you do patent search? Probably literature search, you know how to do. There are scholarly publications, etc. You know how to do that. Similar way, how can you do patent search? You can use something called keywords. In journal writings also, paper publishing, paper writing also, first thing would be abstract generally, then you give keywords. So that keywords helps you to search particular paper in that area. Similarly, the same manner, keywords you can use to collect the kind and number of patents in that particular area. So keyword wise you can do search, subject wise you can do search, then patent title you can give, or maybe name of applicant you can give, patent number, date of application, etc., etc. But the most thing is first one and second one, keyword and by subject, for our this purpose. So what are the resources? There are online patent database, www.ipindia.nic.in, that is Indian patents. You can search all Indian patents in that site. So there are European patents, US patents, Singapore patents. WIPO gives a lot of other resources. Also, if you are not familiar with these things, a general patent review you can do by going to Google Patents. That is google.com/patents. So you go to the Google Patents area. There you can do patent search. I will come to that. So this is Indian database. This is IP site. You can see here patents, then maybe designs, trademarks, etc., GI and etc. So we will focus on patents. So in patents, you can, there are a lot of other searches, patent search for 18-month publication, mostly industries, competitors search that. Then public search for granted patents. Here you can also search. And yeah, this is a granted patent search. And then how do you give the title? Let us say, for example, an example shown is IoT enabled tracking. This is your subject area. You want to know, you want to get a patent in that area. So before that, you should know how many patents are available in that area, and how can I refine my invention to something which I can create novelty, something new in that area. So you give IoT enabled tracking, so you get lot of details of patents. Okay, so from that, one by one you can take, and again, you can restrict it by IT enabled GPS tracking. Suppose in that area also you want to know. So like this, you can do thorough search, and you can get even the details, even the circuit, everything you can get from the patent office. Similar exercise you can do for European database, US database, etc. Already I told you Google patents. There also you can do Google patent search. That is a general search you can do. I am giving an example for probably mechanical engineers. The earlier was for computer science and electronics. Aluminum composite vehicle body. So you want to get a patent, you develop some aluminum composites. So what you do, you simply give the title in the Google patent, aluminum composite vehicle body. You can see number of patents in that similar area. Aluminum composite sheet material, aluminum composite sheet material, another patent. So many patents are available. One by one you can take, and you can see what is that and how your invention is different from that. Is there any difference at all? If at all, what is the difference, and can I claim it as a novelty? So again, you can search for lightweight vehicle body. That also is actually matching or suiting with our theme. So say keywords you can generate in a different way. Generating keyword is in fact an art. That is a technical task and art in patent search. I am not going into the details because that is not our focus. But with this simple method, you can understand the kind of patents that is available in that area with all details. And now coming to the end part of my presentation, suppose you want to do research in exoskeleton to reduce human effort. You know, exoskeletons are used for reducing human effort. How you do a patent review? So you do, of course, exoskeletons are wearable devices that work in tandem with the user. And you know, exoskeletons are placed on the user's body and act as amplifiers that augment or reinforce or restore human performance. So that reduces the task rather. It is an application of robotics and biomechatronics towards the augmentation of humans in the performance of variety of tasks. So lot of advantages. Suppose you are doing a research in that area, you want to get a patent. So you should know at what state is the exoskeleton technology now, and what is the incremental innovation that you have done in that field. Then only you can file a patent. So what you do, you take like that, like I have explained, you do patent search, you type exoskeletons and related subject, I mean keywords you put or subjects you give, and right from the history you understand from the patent documents. There are a lot of things that has been developed. Then you understand. Even in 1960s, U.S. military has patented something. Then again you come with some robotic oriented thing, and other patents in that area. So you can go into details. Since there is no time, I'm not going into that. You will get full specification, all the design details, everything you can get if you go minute in this with this number. So, like this, a team under the leadership of Dr. P.K. Rajendra Kumar, who is the head of the Department of Mechanical Engineering in NIT, National Institute of Technology, Calicut, they have developed an exoskeleton, like doing this patent review, and they got a patent, and you see that is for a low cost, low weight exoskeleton using bamboo and cane as the building material. Okay, so this is possible. So I'm again not going into the details. So sorry, yeah, you can also go to non-patent literature, etc., etc. Okay, so finally you end up with, and this is the patent number and all. So I think I have given a glance, at a glance, what is the role of IPR, how researchers can use IPR for getting a patent, and similar is the process. Another thing you can do is design. Even the kind of exoskeleton which I have shown, that qualifies for design also. Multiple IPs protection is possible. Not only patent, along with patent, the design, how does it look like, physical shape and size. So design you can take. Maybe if you write the directions of use, etc., you can get a copyright also. And maybe you put a mark to that, it can come as a trademark. So lot of multiple IPs are also possible. So this is how you do a patent review, just like you do a literature review, and make use of patent resources to identify the novelty of your research output and get a patent. So once you get a patent, you can publish also. So you get the both advantage of patent as well as publication. And if that sometimes it may be a phenomenal invention, then you can make immense wealth also. So that is all I have to say. And probably maybe if you want more information, my institute, Intellectual Property Rights Information Center, Kerala, at Shastra Bhavan, we can give you more information. Maybe you can email, you can telephone, you can get more resources from this website also. So I think I have done with maybe Jisha or...
Thank you, sir.
Yeah.
Thank you for the wonderful lecture and going through different steps of patents and the benefit of getting a patent and publication and the benefit of publications, and also talk about how to do a patent review and what are the importance of keywords when we go for a searching on any topic. So thank you, sir, for your wonderful lecture. And now I request the, or you can type in.
Research Council.
Ask only one or two questions then to you. Is it possible to apply for patent in India if a similar product is patented abroad?
No.
But not entirely same.
No, why? Because it has no novelty. Already it has got any patent anywhere. It has no novelty. That is what I was explaining.
Okay.
That is why you do patent search, whether it has got patent in any countries. If in any countries it has got a patent, means it lose novelty. So you can't.
Another question is, can you explain about publishing the patented work prior to patenting our product?
Actually, strict sense, I think I have answered that. Better you make a provisional specification, file a provisional specification, and then go for publication. But advisable is that you file a patent and then go for publication.
But the thing is that if you file a patent like 18 months or sometimes it takes like 2 years to complete a patent processing, and so
No, you can always do yearly publication, and you can, only thing you need to pay extra additional fees only. That's all. You can advance that. You can
Okay.
advance that.
Okay, thank you, sir. Thank you, sir. And I think there is no more question. So, thank you, sir. Once again, let me invite Lakshmi Priya, Department of Microbiology, for vote of thanks.
I am also really appreciable the effort taken by MES management. Otherwise, no, I will be failing in my duties. Some 2 weeks before, also in another MES college, I had to give a similar lecture that is on how idea can be translated into a product, the metamorphosis of ideas to a product. That was the talk I have given in another MES college. So, per se, I appreciate, highly appreciate the efforts taken by MES management, especially in this adverse environment of pandemic and all. But still, the visionary management is going ahead with giving this kind of disseminating this kind of knowledge and enriching the faculty in different ways. Once again, thanks and due appreciation from Kerala State Council for Science, Technology and Environment.
Thank you, sir. Lakshmi Priya, please. I think Lakshmi Priya, are you available? I think she's not here. Thank you all for participating and for watching the lecture provided by Dr. Ajit Prabhu, sir, Chief Scientist from STEC and IPR ICT. So thank you all, and I thank Dr. Professor Dinil for the welcome address, and Professor Suresh sir for chairing the session, and thank you all participants. Thank you. See you all tomorrow for the next session, that is for the 4th day of the workshop. Thank you.